Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer with Samfiru Tumarkin LLP, located in Toronto, Ontario. It's great to be back with you all. I've hosted many of these question and answer sessions, and I always enjoy being able to convey my knowledge and expertise of employment law and answer your questions on any employment law topic that you have. So please feel free to send as many questions in as you like, and I will get to as many of them as I can within the time that I have. As I usually like to do, I start off by telling you a little bit about our firm. We are an employment law firm. We also do disability law work. We work throughout the country. Specifically, we have offices in Ontario, British Columbia, and Alberta. And our goal is to service as many Canadians as possible with their employment and disability law issues. With that introduction, I'm going to jump in and talk about a trending topic. Definitely something that has caught the attention of many people and has raised lots of questions, certainly in the employment law world. And what that is the issue of Andy Byron and the fact that he was caught on camera, on a kiss cam, particularly at a Coldplay concert with a colleague. And of course, the footage went viral, and now everyone is blowing up speaking about this issue. And so how it relates to employment law is particularly important because obviously this was a relationship that was consensual between two employees, really. And obviously, as a result, Andy Byron has resigned his employment at the company. But the question really here is this workplace relationship illegal? It's important to understand that it's not outright illegal. There's no actual law that says in Canada that you cannot have a relationship with a colleague. However, obviously it creates issues of power imbalance potentially. It could create issues of consent, conflict of interest, and potentially even a human rights violation. So you got to tread very carefully in this realm. There's no doubt about it. But it's not like a relationship between two colleagues is outright illegal. Okay, very important to note that. So with that, let's move on to our questions. If you have any follow-up questions about anything that I said on that topic, please feel free to address them in the chat, and I'll try to get to them. Okay. We have a question on YouTube from Bright Antelope. We are a sales agency. We hired an employee a year ago. She has failed to reach her targets in 2 quarters in a row, and we have had multiple reviews regarding her poor performance. We let her go because of this. Now she's been sending extremely vile messages to other members of the management team, posting lies online. Yes. So this person wants to know if there's anything that can be done. Absolutely, there's stuff that can be done. Obviously, you're coming from the perspective of an employer. And just for all of you out there to note, we predominantly represent employees, but we absolutely have a good portion of our legal employment law practice that is dedicated towards representing employers. I certainly do a fair bit of that work. And so, yes, if you let go of an employee and they are defaming the company and defaming particular members of the company, of the management team, there absolutely is something you can do. You can commence a legal action against this employee for defamation. You can try to get what's called an injunction to prevent them from actually engaging in this activity. There's lots that is at your disposal. So absolutely, if you are facing this kind of issue as an employer, you don't have to just do nothing about it. There are things that can be done, and you should absolutely contact our firm at help@employmentlawyer.ca so that we can review the issue with you and provide you with very specific advice on how to go about your recourse here. All right. Well, I hope that addresses that question adequately. If you have a follow-up, please feel free to post it in the chat. Okay. We have another question on YouTube from Guy. Do companies have to pay some form of common law or severance in the event of being let go without cause, even if the termination clause is solid for ESA only? All right. So I'm gonna paraphrase a little bit here. What the question is, it is a vitally important question, and we deal with this as employment lawyers every day. So really the question here is, how does a contract, an employment contract specifically, potentially limit an employee's termination entitlements when that employee is terminated? Can a contract do that? If so, how? And if the contract does do that, what kind of severance is being limited? So the starting point for everyone is that when an employee is terminated, they are owed severance pay. Okay, and as Guy noted in his question, that's called common law severance pay. And your severance pay is going to be dictated by various things, including your age, your position that you held at the company, the amount of money you earned in that position, your length of service, your tenure, and generally speaking, how available similar employment opportunities are in the job market at the time of termination and after termination. So those are the relevant questions. Based on those things, each person who is terminated, each employee, will be provided with a reasonable amount of severance. And really the idea of the severance pay is to get that employee from job A to job B. The company that terminates the employee has an obligation to make that employee whole financially in order for that employee to not be without income or their other employment benefits until they find a new job that replaces that income and employment benefits. So that is the starting point. And what could happen, and happens often, is that an employee, when they start a job, they're asked to sign an employment contract. And that employment contract might contain what is called a termination clause, as indicated in Guy's question. The termination clause might have the effect of limiting how much severance pay that employee is owed if and when they're terminated. So even though the employee would typically be owed a reasonable amount of severance based on their age and their tenure and their length of service, etc., that termination clause in the contract might say, putting all that aside, if you're ever let go, you're going to be provided with a certain amount of money as severance pay and nothing more. And if that clause is drafted in a manner that is legally valid, then that is an enforceable clause, and the employee would only get what the clause says that the employee will get. Here's the catch, though. Most of these clauses are not enforceable. I review these clauses every single day. I draft these clauses, and I can tell you that it is very difficult to draft a valid termination clause, which means that even if you signed an employment contract, and even if there's a very fancy looking termination clause in that contract, you know, it has all the fancy legal language and it could be very lengthy, that does not mean that your entitlements upon termination will be limited. It could very well be, and most of the time it is true, that the termination clause is invalid. It's just not drafted properly. It's illegal for one reason or another. I don't have to go into what those reasons might be. That's my job as a lawyer. Your job is to be able to contact us, identify the fact that you might be owed severance, right, if you're let go. And then, of course, contact us and we will help you with analyzing your case and advising you as to what kind of severance you might be owed. Is your termination clause one that is a good clause and does limit your severance, or most likely it isn't. So Guy, I hope that answers all elements of your question. It's a very good one. And like I said, this is probably one of the key issues that employment lawyers deal with every single day. So if anyone has a follow-up there, please let me know and I will address it. Okay, before I move on, we have another question, but I want to introduce myself again for anyone who has joined us recently. My name is Jeremy Herman. I'm an employment lawyer at Samfiru to Market LLP, located in Toronto, Ontario. We're hosting a question and answer session right now regarding employment law. Any employment law issues you might have, this is a free opportunity to learn about those issues. Ask your questions and I will get to as many of them as I can. Okay. We have a question on YouTube from Seaberry. I've been asked by my employer to perform a task that I believe falls outside of the scope of my written employment agreement. I've never been to this site, I guess work site. It doesn't involve our staff or projects. I've been given no tools, training, or safety briefing. This assignment appears completely unrelated to my job responsibilities. Could a suspension or layoff in response be challenged? If I refuse the task, is it reason to terminate me for cause? All right, well, just like Guy's question, this question as well has a lot baked into it. It's a great question. So let's break it down. So starting with the task and whether it falls outside of the scope of your normal job description. Job descriptions are helpful. They do allow employees to understand what kind of responsibilities, what kind of duties they have in the workplace. Very often you might be asked to do things that are a little bit outside of the scope of your job description. And to be honest, that isn't really a legal problem. If they're minor things, companies change and develop and roles and positions develop at companies. And so, yes, your job might evolve a little bit over time. And that might entail you taking on some new duties that you didn't do before. If those new duties are not substantially different, it doesn't change the nature of your job any real significant way, then that's not really a legal issue. Okay. However, if the duties you're being asked to perform are significantly different than the duties you have otherwise been performing in the past, then that is a legal problem. And specifically, that would be considered what we call in the employment law world a constructive dismissal. So it means that your employer may not have said that you're terminated. Instead, your employer has changed in a significant way something related to the conditions of your employment. Maybe it's your duties, maybe it's your pay, maybe it's your hours, maybe it's your job location. Maybe it's has something that has increased your commuting time significantly. All of these things would be legally problematic because those are significant changes. You didn't agree to having those changes implemented as part of your employment. And so you can challenge that. It is a constructive dismissal and you can obtain your full severance pay. There's no doubt. In this case, it looks like Seaberry is indicating that they are being asked to perform different duties. So again, if those duties are significantly different, that is a legal issue, a constructive dismissal. Okay. Now, there could be an employment contract that exists that says that the employer can modify your duties and that you cannot treat it as a constructive dismissal. Again, whether that kind of clause in the contract is enforceable, similar to a termination clause that I was discussing earlier, will depend on various things. We would have to look at the clause and look at the contract as a whole to determine whether there are legal issues there. Another thing I want to touch on from this question is a safety issue. So obviously, if the work you're being asked to perform, whether it's significantly different or just different in a minor way from the normal work that you do, but it has created a safety concern, then you can absolutely refuse the work. And that is your legal right under legislation in Ontario, okay, and really across Canada. So that is just a specific issue dealing with safety. Now, let's get to the latter part of this question because it's very important as well. If you refuse to do work, whether it's for safety reasons or even if there isn't a safety concern, you just don't want to do the work because there's a change that's being asked of you and you don't agree or consent to that change. And in response to you not doing the work, your employer terminates you. Well, that would be what's called a termination without cause. Without cause means simply that you have been terminated, but your employer does have to pay you your severance. Okay? Don't focus so much on the word cause and what the reason might be for the termination. It's not really relevant. If you're being terminated without cause, you're owed severance pay. I will help you determine how much you are owed. Of course, as this question indicates, if you're terminated for just cause, then that is a position your employer is taking where they're saying that you are not owed the termination or severance entitlements that you normally have because you engaged in some sort of really bad misconduct. And if that is true, if you really did engage in that sort of misconduct, you won't be owed your severance pay and your employer will likely be successful. However, most of the time, at least in my practice that I've seen, employers will terminate employees and claim that there is just cause for termination, meaning that the employee engaged in that really bad misconduct. But it's really not entirely true, or the misconduct is not so bad at all, or the employer has condoned that kind of misconduct in the past, or other employees do it as well and haven't been terminated. All of these things would impact whether the employer actually has cause for termination according to the law. And most of the time, there isn't cause for termination when the employer claims it, and therefore the employee will be owed their severance. So don't think that if you've been let go and not offered severance pay, and your employer is alleging all of these things, even if some of them might be true, it doesn't mean that the law would agree with your employer that you're not owed your normal severance entitlements because of that, because of the things that your employer is alleging that you did. Okay, so based on that, I hope that addresses your question. If you have any follow-up, or if anyone has a follow-up on that, please feel free to post it in the chat. Okay, it looks like we have a comment on Facebook from Marilyn regarding being denied disability benefits. So if that is the case, Marilyn, absolutely you should contact us. We have a whole team of very skilled lawyers who deal with the issues of disability benefit denials. As you see on the screen, you can learn more about this at disabilityrights.ca. And absolutely contact us and we'll help you on that. Okay, before we dive into more questions and important topics, what I want to introduce to all of you is what is called the Pocket Employment Lawyer. This is a tool that our firm has developed. You can find it at pocketemploymentlawyer.ca. And really what this is a whole system of knowledge that you can access regarding employment law topics that I've been talking about today. We have tons of information and you can check that out. As well, you can find our severance pay calculator. What that is a free and anonymous calculator that you can use to determine how much severance you are owed based on your circumstances. So as I've been talking about throughout this session, your severance will be dictated by various things, including your age at the time of termination, your position at the time of termination, as well as your length of service, how long you worked for the company, how much money you were earning, and again, generally, how available there are jobs in your job market, okay, in the industry that you were working in. And this severance pay calculator will ask you all of these basic questions. It takes probably 2 minutes to fill out. And then it will tell you how much severance pay you are owed given your circumstances. Again, it's free and anonymous. You can use it as many times as you'd like. You can tell your friends and family about it. They can use it as well. Feel free to use it even if you haven't been terminated, just because you want to get a sense of what kind of entitlements you have in the event that you might be terminated. It's a great tool. So absolutely check it out. Again, find it at pocketemploymentlawyer.ca. We have about 8 to 9 minutes left. Again, I'm Jeremy Herman from Samfiru to Markin LLP, located in Toronto, Ontario. I am addressing as many employment law topics and questions today, and we've been having a great discussion so far. So please post more questions in the chat, and I will get to as many of them as I can. Okay, we have another question from Sheila on Facebook. Sheila says that 3 months ago, she was diagnosed with a spinal condition that requires ongoing treatment. I'm in discussions for a new role, I guess, with your employer. And I'm torn about whether to disclose my condition now or wait until I receive an official job offer. I want to be transparent with the employer, but I'm worried that early disclosure of my condition will jeopardize the opportunity. How do I approach this? Would this fall under a duty to accommodate? Okay, very good question, and I understand the predicament or the dilemma that you're in. It's not an easy thing to have to think about whether you have to disclose a condition to an employer when you may be discriminated against as a result, and you may not get the job. Generally, my approach is that you got to be forthcoming, right? You have to be honest. You have to be truthful. Your employer has to know whether they have a duty to accommodate you. So, if you don't disclose this and then as a result, you require accommodations because of the condition, and your employer finds out too late or doesn't know at all, and they can't accommodate you, that's the problem. It's better that you are forthcoming about the issue. If you don't get a certain position, if you're working for a company and you're vying for a different position at that company, you don't get it, and you think it has to do with your disclosure of your medical condition, then that could be discrimination. Okay? And if you're treated differently because of your medical condition in your employment, then again, that's discrimination, and it's a violation of your human rights in Ontario and across the country. So absolutely don't be concerned about that. It's very understandable that you are, but I do think that you should disclose your condition. And yes, your employer does have a duty to accommodate you. So if you do disclose the condition and there is an accommodation that could be implemented, you are able to perform the job, but there has to be certain accommodations. Maybe it's more break times. Maybe it's that you have different hours of work. Maybe it's that you need a standing desk or different ergonomic equipment. There's many different accommodations that people might need in the workplace, depending on, of course, their medical condition. And so long as your employer understands how they have to accommodate you, right? They are provided with the medical documentation that does not have to address what your condition is necessarily. It doesn't have to disclose any diagnosis. All it has to do is tell your employer what kind of accommodations you need. Your employer can't be expected to do something if they have no idea about it. So yes, they have to be told that they have to accommodate you. They have to know how you must be accommodated. And then it's your employer's job to figure out exactly, how they have to accommodate you. What kind of changes can they implement? And almost always there are things that your employer can do to make the job work for you. Sometimes the accommodation needs are so intense or severe that the employer simply cannot do it. If that's the case and your employer does not accommodate you, then that isn't a failure to accommodate. But most of the time, if your employer is refusing to accommodate you, there's probably a failure to accommodate there, because the law sets out a very, very high threshold as to what is expected of an employer with respect to accommodating employees. So I hope that that adequately addresses your question, Sheila. And please feel free to post any follow-ups in the chat. I'd be happy to get to them. Okay. We have a question on YouTube from Stock. My girlfriend works for a small consulting firm with about 4 employees. She was initially hired as an hourly employee working 10 a.m. to 6 p.m. Monday to Friday. It's been less than 2 months since she started. Recently, the owner called her into a meeting and stated that due to performance and business needs, they can no longer keep her on an hourly wage. Instead, they offered her a fixed monthly salary. She raised concerns that the new offer works out to less than minimum wage for the increased hours. The owner said she'd think about it, but still pushed her to sign the agreement. What can my girlfriend do? All right. So a great question here. Lots of issues packed into it from an employment law perspective. So first of all, this touches on what we were discussing earlier, which is constructive dismissal. If you are paid a certain way, you're paid a certain wage, you earn a certain amount of money, whatever the case might be, and your employer comes along and says that they're going to change that, and they're not going to change it in a small way, they're changing it in a pretty significant way, that's illegal. That is a constructive dismissal. If you have not consented to that kind of change, if your employment contract doesn't permit the company to implement that kind of change, then again, it's illegal and you can pursue your full severance entitlements. Something else to note here is it looks as though these changes that the employer wants to implement is happening within the first 2 months of employment. That could be during a probationary period. So a probationary period in Ontario, at least, is typically 3 months. And so if you were let go during the first 3 months of employment, you may not be entitled to all aspects of your severance. You are probably still entitled to a good chunk of your severance, though. Really, your employer will have to show that if they're letting you go during the probationary period, they're going to have to show that they really allowed you to demonstrate your performance, and you have failed to do so, and it's just not a suitable fit for you to continue working there. If your employer cannot demonstrate that and they just want to let you go and they say generic things like performance issues and business needs, and there's nothing really significant there that they're conveying, then that's illegal, and you're going to be owed your severance. So absolutely, there are things to be done here. The first thing to do would be to contact us at help@employmentlawyer.ca. A lot of good information was provided in this question, but we'd have to learn more about your girlfriend's situation, about whether she signed an employment agreement, when she signed it, how long ago she might have signed it, things like that. Learn more about what her hourly wage is and what is being offered to her now. So that was a great question, and overall a really great question and answer session. It was great being with you guys. We have another employment law question and answer session with my colleague Lior Samfiru tomorrow, Friday, July 25th at 1 p.m. So if you have any residual questions after today, please join that session tomorrow, and all of your questions will be addressed. It was great being with you. Wish everyone a great afternoon and a good weekend, and I will see you next time. Thank you.